from last time? Any questions on fox hunting? Any questions on whale hunting? Any questions on newspaper copying? Any questions on your mind? No? Okay. So we're going to continue this topic of creation of property. And in the last class, we discussed making new property. That is, writing a newspaper, developing an article. Today's class focuses on something a little bit more personal. Property in yourself. Property in your body. Property in your likeness. Your cells, your DNA, your essence. And what I want to discuss with you today is how we understand what it means to have property in your own self. What is the role of the courts in protecting that property? And in something which you may not have even thought of in your brief law school experience, the role of the legislature in protecting property. Okay? So any questions before we get started? Okay. So the first case we have today is actually one of the funner cases of the year. So has everyone seen Wheel of Fortune? Has anyone not seen Wheel of Fortune? Really? Never? Okay. Well, it's fine. They're YouTube. You can watch it later. So Wheel of Fortune has been probably one of the most successful game shows in American history. And since the very outset, one of the hosts has been Vanna White. She's been doing the show since 1982, when she was 25. She's now almost 60 and still doing the show. And the bit of the show, in case for the one of you who hasn't seen it, is that there's a puzzle on the screen. You have to guess letters. You spin a wheel and try and guess. You know, get the general premise? I do. Okay, good. And you try and guess it. And so the conceit is Vanna White stands next to this game board. She has a very distinctive dress. And at various junctures, if I guess an R, and there's an R there, she goes and she flips the letter around. I understand now she doesn't have to flip the letter. She taps it and the letter changes. I guess that's robots taking over her job, which is very much like this case. So in the 1990s, Samsung decided it would be a great idea to have an advertising campaign with this cartoon. So it depicts a robot, which looks a lot like C-3PO from Star Wars, with a blonde wig, a flowing ball gown, the very gaudy jewelry, and she's flipping letters on a game board, which, you know, for anyone who's watched TV, that's pretty much a distinctive feature of Wheel of Fortune. And you can see the caption says, longest running game show 2012 AD. Now, this was published in the early 1990s. So this was saying, you know, in the year 2012, right, Wheel of Fortune will still be on TV, except Vanna White will have been replaced by a robot. Okay, so it's funny, you know, she's still there, and she looks more or less exactly the same. She does. And then below that on the commercial, I'm going to scroll down, there's a picture of this thing. Does anyone know what this thing is? Okay, there will come a day when I will teach this case, and no one will know what a VCR is. You perhaps saw some vestiges of, you know, the video cassettes from Disney, whatever, right? But there was a time when a VCR was a very big deal. This was a new technology. It was innovative, right? And this is, again, fast forward VCR, right? Samsung. The VCR that you'll tape it on in 2012. Samsung, the future of electronics. So, again, the conceit is this, right? Haha. In 2012, Vanna White will be replaced by a robot. But in 2012, you'll still be using a Samsung VCR to record Wheel of Fortune. Okay, so this is, you know, it's funny teaching this case 3 decades later because it's absolutely false. VCRs have gone by the wayside. I don't think you can even buy them anymore. I don't think anyone makes them anymore. Maybe they do, but it's long gone. At other similar advertisements, I found one of the other ones. There's a picture of a steak that's raw, and it says revealed to be health food in 2010 AD. So the idea is, you know, even after you know, time passes, people are still using a Samsung microwave for the health nuts that will cook it in. So this is the you know, this is the general conceit of the advertisement. And even now, 30 years later, when you saw this commercial, how many of you thought, oh, that's Vanna White? A lot of you, yeah. That is what the marketing agency was clearly trying to do. They were trying to evoke the image of Vanna White, make you smile, make you laugh. A couple of you chuckled. Maybe some of you had no idea what the idea was, but for the most part, you chuckled or laughed. But so where's the property issue, right? Right? Where's the property issue here? Okay, so where did I finish last time? That you raising your hand or you were last?
I think you finished close to me, so it's fine.
Okay.
I actually have a
Is that Pierce?
Yeah.
Okay.
Why is this not considered satire?
Oh, what a good question. What's satire?
Well, basically, satire is like in the newspaper where you can have Donald Trump with a bird in the hair or something.
Right.
I know that that's somewhat protected.
So, okay, so we'll get to the First Amendment in about 20 minutes.
Okay.
I promise I'll get there, but I'm going to start with you because you raised your hand. So, the first question, right, is what is Vanna White's problem, right? Why did she sue Samsung? What was Vanna White's objection?
She said that she had a right to her likeness and that they were using it without her consent.
Okay, she had a right to her likeness. That's exactly right. That was her claim, right? That Samsung used her likeness without her permission. And okay, is that Arusa? Arusa, what is this likeness? What does that even mean? A likeness? What is that? A little bit louder. I can't hear you.
I think it would mean that it would be recognizable as you, like you're making a name.
Okay, is her name anywhere there? Is her picture anywhere there? Okay. Well, her name's not there. Her picture's not there. So then, what is this likeness business?
I think it's because, like you said, it evokes it.
Ah, it evokes, right? So Vanna White didn't claim that they wrote Vanna White there, right? Her name appears nowhere. There's no picture of her. In case you don't know, this is what she looked like at the time, more or less. I mean, she looks about the same right now, but that's what she looked like at the time. So her picture's not there, her name's not there. So is that Ryan? Ryan, what then is the objection? What exactly is she complaining about?
She's complaining that whenever you look at the ad, it was supposed to, if you could really infer that it was her.
Okay, good, right. When I look at this commercial, there's an inference, right, that we're talking about her. But why is that problematic? Is that Amala? Why is she offended that when I look at this commercial, I think of her? Isn't this like what all celebrities want, that we think about them and we, they're in the news? I mean, the worst thing for celebrities is that no one talks about them. That's why they always do stupid things to get attention, right?
Well, it's because she had confronted them more where she hated them.
Ah, bingo. That's a big thing. Vanna White has no problem with people talking about her or keeping her in the news. She wants to get paid for it, right? Like any good celebrity, she's okay with publicity so long as she's getting paid, right? All these celebrities are always being photographed by the paparazzi. They often stage these shots and get paid for them, right? This is part of the game. They want to be compensated for this sort of attention. So she sued, and she brought a number of causes of action. And a lot of these causes of action actually sound in tort. So did you guys in tort study the privacy torts? Okay, so I'll go over them very quickly. The restatement second of torts has a brief discussion of privacy torts. And these are based on a landmark article by William Prosser, who was a professor at Berkeley for a number of years. And the book mentions these torts. So there are these 4 privacy torts. I'm going to mention them very, very briefly, just so you know about them. First one's intrusion upon seclusion. The second one is appropriation of image. The third is a public disclosure of a private fact. And the fourth is false light. For the most part, most states have adopted most of these. That wasn't very reassuring when I said this. Not all states have adopted all 4 of these in their entirety, but in most states, these are more or less the known privacy torts. Intrusion upon seclusion, what does that mean? That's your classic case where someone takes like, a supersonic lens and like zooms it into your window and photographs you like, in the shower or whatever, right? You can't intrude upon a place of privacy. The second one, appropriation of image, that would be if they actually use a picture of Vanna White spinning the little tiles without getting permission, right? They're actually appropriating her image. The third one, public disclosure, private fact. you know, that's like if someone has cancer, some really, you know, serious disease or keeping private, and you blast that on the newspaper. What about the First Amendment, you ask? These torts are very often in conflict with the First Amendment. It's unclear, in my opinion, if they're even constitutional. But there's generally a newsworthiness exception where something's of public interest. You can actually go ahead and disclose facts. Like, you know, say if, you know, a presidential candidate was found to have cancer and she was keeping that secret, well, maybe that would be something worthy of publication. And the fourth one is false light. Imagine they said, you know, Vanna White endorses Samsung VCRs, and she never endorsed it, right? You are portraying her in a light that is not accurate. This is don't the claim that Vanna White brought doesn't fit into any of these four, right? It doesn't use her likeness. It doesn't use her image. There's no public fact about her that's disclosed. She was not able to fit her claim into any of the known privacy torts. So we have a problem, right? Norma, let's flash back to last week and go back that far, right? Do you remember I said the case, the INSVAP case, this is a case where one newspaper was copying this or the other? In that case, let's just think back for a week. Could the newspaper have copyrighted their article? Could the newspaper have, you know, in theory at least, copyrighted their articles every day they were published? They could have, did they?
No.
That's right. If you recall, the Associated Press could have copyrighted their articles, but they didn't because it was too expensive, it was too time-consuming. They publish newspaper every day. It's a waste of time. So let's go to the back. Is that Jackie? So Jackie, we know that under the statute Congress passed, right, there was no copyright there, right? They could have copyrighted their articles, but they didn't. So how did the court rule in favor of the Associated Press? How did the court go about giving them a remedy? What method did they use? What kind of law did they use? What did they call this sort of right? Thinking all the way back to Thursday or Tuesday, whenever it was. Well, Jackie, let me ask you the question like this. Did the Associated Press comply with the statute? Did they comply with the Copyright Act? Did they actually go ahead and copyright the article? No. So if there's no statutory law to support the court decision, what did they use? Common law, bingo. Common law. Right? And remember this. Basically, the Supreme Court made up common law. The Supreme Court made up a common law ruling about what types of quasi-property rights are protected. Remember this? Right. And as I said last week, I'll say again, federal courts do not make up common law where there's a statute in place. Right? And again, we discussed Erie. There's no more federal common law. This was before Erie. So here are the courts in a similar position. California does have statutory law concerning property, right? The first cause of action is something called appropriation of likeness. Right, and the statutes was section 3344, whatever, right? Law students hate section numbers, but it effectively says you can't use another person's likeness without their permission, right? This is basically number 2. You can't appropriate their image. You can't appropriate their likeness without their permission, right? It's more or less tort number 2 that I mentioned above. So Ross, we already said this, but did Samsung actually use Vanna White's image? Did they use her likeness in any way? No. I'm asking you as a reasonable person looking at this ad, is Vanna White's image there? Is her likeness there? You would say yes. Why would you say yes? No. Well, no, but I want to be very precise here, right? This is what Vanna White looked like. That's what she looked like. Okay. Is her image or likeness anywhere in this picture? Okay. So you're right what the court holds, but I want us to talk about reasonableness first, right? Under the statute, her image or likeness is not used here. There may be something that makes you think of her, but that is not her image or likeness. And the court acknowledges this. The court even says, quote, "This is not a likeness of Vanna White within the meaning of 3344. This is not a likeness of Vanna White within the meaning of the statute. The court acknowledges this. So here we have a similar situation like last week, right? There's a statute, right? California passed a statute, Congress passes a statute, and the statute provides some form of protection for intellectual property, but not infinite. And here the court says Vanna White does not get any benefit from the statute. So is that Alyssa? So Alyssa, once again, since the statute does not provide the remedy, what does the court do here? Where do they turn to? Jackie just said it a minute ago. Common law, bingo. Common law. The Court of Appeals, the Hollywood circuit, right, turns to the common law, and they develop this new quasi-property right. Does everyone see the parallel between the INSVP case and this one? It's the exact same thing. The legislature provided some limited remedy. The remedy wasn't adequate, so the court created a new property right out of thin air. And Judge Kozinski's opinion, guess that. Yes, ma'am. What case after this are you talking about?
Is there something that's...
Oh, is there? Ask me the question in like 10 minutes, okay? We'll get there. The short answer is this is still good law, but we'll get to what happens afterwards in a few minutes, okay? All right, so Jake, how does the court turn to the common law? And again, never forget, law students, common law means judge-made law. There's nothing wrong with common law, but there's a tension when there's judge-made law when you have a statute, right? The legislature said, here's the statute, here's your specific remedy, and the judges say, we'll do some other stuff too, right? There's a tension there. So, Jake, how does the court look to this common law judge-made development of law to develop this new conception of likeness? What exactly are they doing here?
Look at Prosser.
Prosser, yeah. Who's this Prosser guy? It's a law professor. What do you mean judges? Judges are looking to law professors? Man, we're in trouble if law professors get to decide the state of constitutional law. We are in serious trouble. Well, yeah. He by the way, these 4 torts I mentioned a moment ago, he developed these. This was his, landmark article where he put these 4 torts. But what does Prosser say then, Jake? Okay, in your own words, don't read. Don't read. Tell me in your own words.
They took advantage of her image.
What do you mean they took advantage of her image? You're on the right track. Give me more.
People know that she is the host of that game show, and just because they took advantage of that fact without using her actual likeness or image, they knew people.
Ah, okay. So what does Prosser write? Okay. Prosser says it's possible to appropriate an image. It's possible to appropriate the plaintiff's identity without the use of his likeness. So Prosser suggests in this article I mentioned, that even if you don't use the person's actual likeness, you can still appropriate the synonym for take advantage of, right? You can still take advantage of the person's identity. Okay. And there's one of the funnier cases mentioned. So, Tim, do you ever watch the old Tonight Show with Johnny Carson? Do you know about it? Yeah. What was the signature line whenever Johnny Carson came on the set? Here's Johnny, right? Ed McMahon. How many of you actually knew that? Wow. Okay, you guys are cultured. Good. I every year I teach this case, I fear that number will dwindle further and further lower. But yeah, so Johnny Carson, so before Jimmy Fallon, before Jay Leno, was the host of the Tonight Show. And every show, Ed McMahon would go, here's Johnny, right? That was his introduction. So a company in, I think it was Ohio somewhere, made a line of portable toilets, porta potties, right? Called Here's Johnny Portable Toilets, right? Johnny, right? Haha. Whatever, right? It doesn't have to be funny. But he was attempting to use this, this very well-known TV introduction, Here's Johnny, to sell a toilet. So, Tim, is that appropriating Johnny Carson's image, the fact that you're, using this phrase that's very commonly associated with Johnny Carson's show? Yeah. So in this case, the court actually held that using this slogan from a TV show, right? Even though they didn't put a picture of Johnny Carson on the toilet, right? He wasn't there. But this phrase from this TV show was there. Now, Brian, what's the distinction between using the exact same phrasing from the TV show, Tonight Show, and using a robot that looks like Vanna White? What's the difference there? Good. And what about this? Is it an exact copy of Vanna White? Good. Okay. So everyone see the distinction here, right? If I copy, use an example, Live from New York at Saturday night. Okay, people might know that one more. That's Saturday Night Live's introduction, right? There's no mystery. It's a one-to-one. But here it's like, oh wow, that looks like Vanna White, right? There's a mental process that has to connect the two. The synapses have to fire. Whereas Here's Johnny or Live from New York at Saturday night, these are direct copies. Okay. And to give you an example of Texas one, everyone knows the Texas A&M Aggies 12th man, right? The Seattle Seahawks had a copyright dispute because they have the 12th man in Seattle. Okay, so whenever people see the 12th man of Seattle, they might think of the Aggies. There was a huge copyright dispute when they were in the Super Bowl a number of years ago. So there's that issue. So the court here, what they effectively do is they create, I'm not going to call it a fifth tort, but they expand number two. And what they effectively say is we're not just talking about a person's actual image or likeness. What we're actually talking about is something that makes you think of, or something that evokes, if I may, the likeness or the image of a person. The court writes, this ad has, a robot with a long gown, a blonde wig, a jewelry. There were block letters in the game board. Okay. The defendants themselves call this a Vanna White ad. When the defendants were designing the ad, they thought of, okay, how do we make this look like Vanna White, right? This was very clearly what they were trying to do. So the majority opinion rules in favor of Vanna White, and I think it was like $400,000 of damages. I mean, it was not an insignificant amount of money. It was this is 30 years ago. This was a fairly, it's a nice chunk of change for a cartoon about a robot that doesn't even use her picture. Okay. So any questions in the majority opinion? We'll get to the other opinion in a minute. Any question in the majority? Yes, in back. Oh, good question. So what's the name of the case? Go to the first page. What's the name of the case? Who are the parties? Yeah. Who are the parties? White.
Yeah. I was wondering
So let me ask you a question, actually. Hold on. Matthew. Now, with all respect to Vanna White, I'm sure she was she's a brilliant, actress and a talented game show host. Do you think this was her idea, this persona, that she created this persona all by herself, of wearing this outfit and going in front of the game board?
Created by herself.
Do you think she did all this by herself? Who do you think may have had a role in creating this persona? Pat Sajak, or actually Merv Griffin, right? To be precise, right? Merv Griffin is this legendary game show host producer. He created, I don't know if he created, but he basically developed Jeopardy. He developed Wheel of Fortune. I'm willing to wager, and I don't have any inside knowledge, that Merv Griffin had the idea of having a glamorous woman flip tiles, and he hired stylists and makeup designers and clothing designers and game board designers to create the image of Vanna White in front of the game board. So, Tim, I think your question is a smart one. Why is Vanna White suing and not the Merv Griffin company, which makes Wheel of Fortune? What do you think, Tim?
I think you didn't want the publicity.
Yeah. Right. Wait, well, we didn't want what publicity?
Well, he had a lot of irons in fire. He also runs a lot of other production.
Ah,
He didn't want to blow back.
maybe, right? So I think this is actually mentioned in the Dissent, but maybe the true party interest wasn't just Vanna White, but Vanna White shared with Merv Griffin because he helped create this image of her. As much as we love Hollywood people, they're just acting a role. We often forget that. They're reciting lines. They're doing what someone else tells them to do. So I don't think, with all respect, I don't think she owns the entirety of her identity. I think other people have a pretty strong claim to it, but that's a good question. Yeah, that's, hold on, Justin?
I mean, it seems to me like I'm a Star Wars to see because that looks like C3.
It does. That's what I said at the outset, doesn't it?
So,
George Lucas perhaps in, fortunately, you didn't notice, he was off making special dishes at this point, so he was fortunately distracted. Sour grapes, I suppose. So that was the majority opinion. Now, I want to explain an attribute of appellate procedure which you may not have been exposed to. So as I'm sure this part you know, our federal court system has 3 tiers, right? You have the district court, which is the trial court. You have the circuit court of appeals, which is the intermediate court, and then you have, of course, the Supreme Court. Okay. Now, the United States is divided up in a map, and it's chopped up into lots of districts. So, for example, in Houston, we are in the Southern District of Texas. If you go to Austin, you are in the Western District of Texas. The states are chopped up. But even more than that, the country is divided among different circuit courts of appeals. So there are 13 circuit courts of appeals. We are in Texas. We are in the 5th Circuit Court of Appeals. It involves Texas, Louisiana, and Mississippi. Okay? The 6th Circuit, where I clerked, is Ohio, Michigan, Kentucky, and Tennessee. Oh, in almost every case at the district court, cases are heard one judge at a time. Okay? You get assigned a case, you file a new federal lawsuit, one judge hears it at a time. When you appeal to the courts of appeals, you have what are called 3-judge panels. 3-judge panels in the Court of Appeals. When you argue to the Court of Appeals, you go to New Orleans, the 5th Circuit, you have a 3-judge panel. How does it work? A majority vote. If all 3 agree, great. If 2 go one way and the other one dissents, the 2 judges are the majority. Okay, everyone, that's easy enough, right? But there are far more than 3 judges in a Court of Appeals. There can be as many 25 or 30 judges in the Court of Appeals. So what happens if the 3 judges on the panel think one thing, and then the other 22 think, what are you guys, nuts? Right? Are you crazy? There's a procedure by which you can rehear the case as a whole. Okay? This is something called en banc, or en banc, depending how you say it in Texas, right? En banc or en banc means the court as a whole hears it. It's actually Latin for from the bench, but that's not how it's translated. So what can happen is, so say 3 judges hear it initially, and they screw up. They screw up big time. If a majority of the judges on the court want to rehear it, then all the judges hear it a second time. So instead of having 3 judges, you can have as many as 10 or 15 judges hearing the case. I promise I'm going somewhere with this, right? So in this case, in our Vanna White case, what happened? The 3 judges ruled one way. And afterwards, there was a vote. Say, hey, these judges just made up this common law right. We want to rehear it. There was not enough support. There was not a majority support to rehear the case. Okay? So, if there was not enough majority support to hear the case, where did that dissent you read come from? What is this dissent that you read, right? How can you read a dissent if all 3 judges in the majority opinion, agreed. So I'm going to teach you a new word today. Okay? I feel like Sesame Street. The word of the day is dissental. The word, dissental. It stands for, it's a portmanteau actually, of dissent from denial of rehearing en banc. I'll explain this. Dissental means a dissent from denial of rehearing en banc. Okay? What does that mean? There was a vote to rehear the Vanna White case. The majority of the judges in the Court of Appeals said, no, we don't want to hear it. One judge said, you know what? I am going to dissent from the denial of rehearing. Let's say it again. There was not enough votes to rehear the case, so one judge, this guy named Judge Kozinski, dissented from the fact that his colleagues did not want it. It's called a dissental. And I say this loosely because Judge Kozinski has been on something of a vendetta to make this a real word. He's actually pleaded with Black's Law Dictionary to add this to the dictionary. It did not make it to the 8th edition. I think it'll be in the 9th edition. And I've actually, I swear, one of my students last year used this word in their exam, and I submitted that as an affidavit of why this word should be added to the dictionary, of Black's dictionary. Anyway, this is his mishigas, you know, the word. This is his thing. But anyway, I think it's a useful term to explain what he did. Judge Kozinski was not on the original 3-judge panel. He was not. But he decided to dissent from the fact this court didn't want to rehear it, and that gave him a platform to write something. So, with all respect to his honor, the dissental is merely an opportunity for a judge not on the original 3-judge panel to say something. Okay? And more often than not, the purpose of a dissental is to flag the issue for the Supreme Court. Let me say it again. The purpose of the dissental is to flag the issue for the Supreme Court and say, hey, SCOTUS, right, Supreme Court of the United States, we screwed up here, right? We screwed up. You guys should take this. And if you read Judge Kozinski's, very colorful dissental, he's making the point saying this case warrants a second look, right? You notice that at the end he was saying this case should get another look. He was talking to the justices. So the purpose of this dissental, if I may, was to simply flag it for the Supreme Court. Now, I think Ross or someone asked me a few minutes ago, what was the outcome of this case? Did the Supreme Court take up Justice Kozinski's heed? No. It was noted afterwards that certiorari was denied. The Supreme Court accepts cases in what's called a writ of certiorari. Writ of certiorari, which basically means the Supreme Court decides to take a case up. They have a discretionary docket; they're not required to take any cases. So despite Judge Kozinski's, most zealous advocacy that his own court, the Court of Appeals for the Hollywood Circuit, as he calls it, screwed up, the Supreme Court was not interested in fixing this error if it were one. As a matter of course, the Ninth Circuit is usually the most reverse circuit in the country. It's from California, and they are almost always out of the mainstream, although the court I clerked on, the Sixth Circuit, is given a good run for the money because the Sixth Circuit still executes people. Ninth Circuit's basically stopped. So a lot of their craziest cases have gone away. So the Sixth Circuit has not picked up that mantle of craziness. So so this is Judge Kozinski's platform and opportunity to weigh in on an issue which he otherwise has no opportunity to say anything. Okay. All right. So any questions on the appellate procedure? You'll never forget this word. The book does no effort at all to explain why Kozinski's writing an opinion at all. It just says Kozinski dissenting from what. So now you know how this works. If you don't like the 3-judge panel, you can seek rehearing en banc. If you don't like that, then you go to the Supreme Court. Questions? If you learn nothing else, you'll remember dissental. Not to be confused with a concurral. if I may indulge you one more moment, the concurral, which is a concurrence, these are real things from denial of rehearing en banc. But as a concurral, that's where a judge agrees that the case should not be reheard, but it's basically responding to the dissental, right? So the concurral responds to the dissental. Lawyers make up the craziest stuff. we have way too much time on our hands. Anyway, now we'll move on to the actual case. So Judge Kozinski begins. Something very dangerous is going on here. Mary, what's dangerous? What's something strange in the neighborhood? Like what's going on here, right? What's the problem? Sorry, say that. I didn't hear what you said. Say it one more time. Okay, so let's talk about this for a second, Mary, right? What is the downside? What is the cost for ruling in favor of Vanna White here, right? What is the cost of giving this case? Oh, it takes away incentives for innovation. Justin, where have we heard this before in the case we've studied so far, that if you assign a property right in a certain way, it can eliminate incentives to actually work more? Where have we heard this before? Give me one. The Fox case, right? Guys, I told you, right? The Fox case provides a basis for the entire semester, right? Pearson. Justin, tell me, how does the Fox case, we discussed the first week of class, explain creation of commercials and robots? Like, what's the connection here?
Basically, to go hunt the fox took effort.
Good.
To create commercials, it takes effort.
Yeah. Use the word labor instead of effort.
Okay, sorry. Labor.
Good.
Then
Yeah. So think about this, right? You may not have actually considered this before, but intellectual property, whenever you say you can't use this image, you just limited creativity, right? It's one thing to say, if you use an actual picture of Vanna White, you're going to get sued. Okay, I think people can probably agree it's a good idea if you use Vanna White's actual picture. But now, if you create a process, right, that makes you think of Vanna White, that can get you sued also. Justin's exactly right. That can stifle creativity. You are limiting the scope of things that you can create. And even on a more fundamental level, right? There's nothing new under the sun. There's nothing new under the sun. Everything we create is based on what came before us. I don't care how smart you are. Anything you've done, someone did before you. It's a fact of life. You realize this the older you get. Everything's been done already. There's nothing new, right? Simpsons did it. Everything happened. It's true. And before the Simpsons, there was, other stuff, right? So what Kozinski's saying here is that whenever you expand protection for intellectual property, you contract the scope. You limit the supply of material which people can creatively innovate with, right? When you take an entire area out of the market, you limit. Okay? So Kevin, let me ask you this question. What does Judge Kozinski think, though, in terms of the role of the courts? Who should be responsible for deciding what property rights are protected and what property rights will not be protected? I'm sorry? To the jury? In terms of our system of government, right? The legislature. Why should the legislature be responsible for deciding the scope of property protections? You gotta be loud, I can't hear you. What do you mean it's their job? What does that mean? Why can't the courts do it? Sarah, what's the risk when the courts start expanding the scope of these statutory privacy torts? What's the risk?
I guess unforeseen.
What do you mean? You're on the right track.
I guess it could change the way people do advertisements and things like that if they rule a certain way. Like more policy.
Good. Sarah, let me ask you a follow-up, please. When the legislature passes a statute, was it 3344, whatever the section was, right? And they define with specificity what you can and can't do, right? They say you can't use a person's likeness. Is a court decision that clear? How do courts generally make law? What do they generally do? You've been doing this now for 2 semesters.
And we interpret it as.
Yeah. So in other words, instead of having a clear statute saying you can do X, but you can't do Y, here now you have a court decision, which you have to read and interpret, and it's up for debate. So one of the virtues of legislatures acting is that they can act precisely. Courts can't. All they can do is develop principles which can apply here and maybe not there and be distinguished. There's no certainty, right? So Kozinski basically says one of the risks of this common law approach, one of the risks of the common law approach is that people won't actually know what the law is, right? So is that Hunter?
Richard, my chair's broken.
Your chair's broken. Oh, that's not good. Oh wow, we should probably call someone for that. Okay, we'll call later. Wow, that's really weird. Okay, all right, Richard. Thank you. Sorry about that. So Richard, let me ask you this question, right? Let's say, I'll use the example Pierre said a second ago. Let's say you want to do a commercial of Donald Trump, some cartoon character with a bird on his head, right? Can you do that under the law now in California? Just whatever, some guy in a suit with a bird on his head, right? It doesn't have to look like Trump.
Well, I mean, you can do parody.
Why can you do parody? Or use satire is actually a slight difference, but why can you do parody or satire?
Because
You're on the right track.
because it's like
Yeah, certainly it makes fun of people. Brenda.
or like our comedy, or like our
Brenda. So right. So you ever watch like Saturday Night Live or one of these shows? And they rip off, celebrities all the time. They have a guy dressed up like Hillary Clinton, Bernie Sanders, have a woman dressed like Hillary Clinton, like the guy dressed up like, Donald Trump. They're unlike this cartoon, they are clearly appropriating the image of, these celebrities, right? Why are they not getting sued for stealing the likeness of, Kardashian, whatever celebrity they make fun of, right? Why are they not getting sued? Let's pretend they don't like it. Like, let's say there's an episode of Saturday Night Live where they just absolutely destroy Kardashian, right? They make her look like an idiot. Freedom of speech. Where does the First Amendment come into play? Why is there a freedom of speech issue here, right? Okay, so let me stop you right there. The First Amendment protects offensive speech. I don't mean to pick on you, but it's a very common sentiment that people are today that if something's offensive, the First Amendment doesn't protect it. False. The First Amendment protects offensive speech. If I say something that offends you, I'm acting within my First Amendment rights. Okay? Unless my speech actually incites imminent violence, I cannot be censored. I didn't mean to pick on you, Brenda, but I always like to bring that up at some point in the semester. Offensive speech is protected. If it makes you feel bad, too bad. Okay. So, Erica, let me ask you this question, right? Why do you think it's important for society to have a show like Saturday Night Live or The Tonight Show, whatever it is, where they parody particular politicians and they ridicule these people? Why is that important for society? Yeah, it's a very effective means of criticizing someone when you do it through humor, right? It's one thing to write a 2,000-word editorial criticizing a candidate, and it's another thing to have a funny skit on Saturday Night Live where you ridicule the person, or a cartoon with Donald Trump with a bird on his head, right? People like humor. People like laughter. It's an important character of human nature to laugh, right? When I saw this ad for the first time, I chuckled. Not a lot, but I chuckled, right? It's important. So what Kozinski is basically saying here is that the First Amendment protects our rights to have innovative thoughts, right? It protects our rights to have thoughts that make us think of other things. And if now the court's holding stands for the proposition that anytime you write something or you say something that makes you think of something else, you can be sued, that chills innovation, right? That's a restriction on speech. This is why the Court of Appeals for the Hollywood Circuit, as Kozinski calls it, has now said that you do not have a right to mock someone, that you do not have the right to parody someone. So in much the same way that INS v. AP created a quasi-property right out of thin air, this case did as well. And it had the implication of basically ignoring statutory law, but also, and I agree with Kozinski here, running straight into the First Amendment. And that this does have very, very chilling effects on speech. Okay, but that was a dissent, and someone asked me a few minutes ago. Supreme Court denied certiorari, so the majority opinion is good law in California. So that is a state of affairs. Yes, hold on. That's Jamie? Yes.
So I was just wanting to clarify, so parody is okay?
So under constitutional law, parody and satire are permissible.
Not just because it makes you laugh, I'm assuming, right?
Well, what the courts have effectively said is the reason why you can get around the torts is because it's an important aspect of society, of which humor is an important way of expressing ideas. I mean, that's not the holding of the court. What they did is it gives a release valve for society, allows them to comment on public issues. So humor is actually a very important part of the First Amendment analysis, that it allows you to express yourself in comical ways.
It has nothing to do with maybe like a profit component to it.
Okay. So let me ask you a question, right? What happens if you know you decide to, I don't know, take a picture of a politician, right, and say, you know, John Smith agrees with me about, you know, whatever, and then you sell that picture on a postcard. What do you think happens there? You're basically taking a picture of a politician, you're saying John Smith agrees with me, and then you sell this postcard. Right, because in that case, you're not just editorializing or satiring or parodying. You're actually profiting off the image of someone else. I think this actually this comes up very often when you use a politician's image in a way they don't, you know, endorse. So to the extent that politicians and other newsworthy figures are exempted from the privacy torts, it generally goes up to the line of whether there's a commercial component. Now, does SNL have commercials? Are they charging advertisers? It's very uneasy, and for the most part, politicians are not that stupid to sue whenever they're, you know, in the news, because it gives you free publicity. For whatever reason here, Vanna White decided to go to court. Merv Griffin didn't, but Vanna White opted to go to court. Okay, other questions in the Vanna White case? So was that a hand? Yeah. Is that, hold on, is that Christian?
Yeah, I have a question regarding the third and
Yeah.
So when they're defining whether something's a parody or satire, do they have to find it objectively intending to cause humor? Because I remember that guy with Weird Al Yankovic.
Oh yeah.
Okay.
So
He's making money off these songs. I remember
yeah.
with the rapper that became
Yeah, Amish Paradise.
Coolio.
Amish Paradise, yeah.
And the Amish Paradise, he sued because he didn't think that song was
So there's actually a difference between satire and parody. I think I may have quickly described them, but a satire is where you take something that actually happened and you kind of make fun of it, right? Weird Al does something that's more of a parody, where you basically take a song and a lyric and you put new words to it. Unlike satiring a political event, you're basically copying someone else's music, and music is copyrighted. There is something called fair use, which you can learn about in a much later class. But for the most part, Weird Al gets really close to the line, if not breaks it. I think nowadays he asks for permissions in advance, so he doesn't get sued. Sir?
Yeah, what like when there's like a focus song, so it's like actually just sing the song. It's a bunch of songs.
Well, if he's using someone's copyrighted music, I hope he has permission. Yes, ma'am.
Do you think the majority decision was also wrong?
Do I think that what?
The majority's opinion is wrong?
Do I think it is?
Yes.
You know, for the reasons Judge Kozinski pointed out, it's very hard to reconcile the majority opinion with the statute. I mean, if you think that the court properly extended the common law and that's their province, then it's okay. But it's hard to reconcile the majority opinion with the actual statute on point. As I said last week, when you have a statute and the legislature made a law in an area, that's generally a hint that courts should not be expanding it on their own, right? We don't you know, if the law is silent, the common law is a stronger presumption, but where the legislature acted, the presumption is the legislature didn't want Congress or the courts to do stuff.
Yeah, I'm just having a hard time identifying kind of like what would be the difference between this case, and the international press on that property decision.
Right. I mean, they're very similar. I mean, that's why I compared them the way I did. So that, I mean, there's similarities between the two of them. I saw a hand some over there. Anyone else? Anyone else? No? Okay. All right, let's move on to the second case. And this is actually a really interesting case involving property rights in your own body. And I hope you enjoyed reading this one because it's a little bit of a different case. So first, let me give a background to understand. So there's a little biology involved here. We all start off, as, cells, right? And through the miracle of whatever, our cells grow and grow and grow, and cells regenerate. And eventually we come out as babies, grow and become taller and taller and taller, and you make new skin cells, you make new bone cells, you make new organ cells, right? We start off as a pinprick and we become really big. The way this works is that our bodies are able to generate new cells, right? The reason is if I cut myself, new skin will grow back because I have magic in my body, whatever, that can create new cells. I'm trying to explain this for law students, right? Cells regenerate. But generally speaking, after you die, right? After you're no longer living, your body stops generating cells. That's why you decompose. And that's why you rot. That's why you don't keep growing indefinitely. Some people, and by some I mean very, very few people, have magic tissue. They have magic tissue. What do I mean by that? Even after the tissue is removed from the body, it continues to generate new cells. Even after the tissue is removed, it continues to generate new cells. Now, the cells they create are not actually of the person. What do I mean by this? Your tissue, right? So if someone takes, part of my spleen out, that spleen is me, right? That has my DNA in it. But the cells created by that spleen do not. So even though the spleen was part of me, the resulting line of cells that it created are not part of me. It doesn't. They're generic cells like anyone else. The cells we're talking about don't actually have DNA in them. Okay? That's what I'm trying to explain. The actual cells being created are not your DNA. What to use your DNA is your spleen. Okay? Everyone get the science, at least. If you don't understand, I don't care. But at least you understand the general principle of how this works. And it's actually important because at issue in this case is not the spleen, but the resulting cell lines created from Moore's spleen. And that's why it's actually salient. Moore isn't suing over the fact they took a spleen. The spleen is worthless. What actually has value were the cells created. So let me actually give you the background, very few facts. So Mr. Moore was working on Alaska pipeline. And then one day, I think he was 31 years old, his gums started bleeding, his belly swelled up, and he had bruises all over his body. He thought he was dying. He went and he was rushed to the University of California Medical Center, and they found that his spleen, right, it's an organ. A spleen usually is 1 pound. His spleen weighed 22 pounds. So you can imagine his spleen had just exploded and it was about to, burst. So they removed his spleen, and when he removed it, it was actually a consent form that said, do you give the hospital permission to dispose of any severed tissue or member by cremation? Whatever, the guy was going to die. He signed the form. Right? He didn't really care whatever the form said. And this was in the 1970s. So between 1976 and 1983, he was living in Seattle. And then several times a year, his doctor in California asked him to fly from Seattle to California, Los Angeles, to get a follow-up test. Now you may ask, why would he need to go all the way from Seattle to California to give blood work, right? To take a test. And at first, Moore, who, as best I can tell, he's an oyster salesman, didn't really mind because they offered to pay his airfare for him to travel. And they put him up at the Beverly Wilshire Hotel, which I think may have been owned by Merv Griffin at one point, right? I didn't think it was a bridge between those cases, but apparently there is. So basically, they're flying this poor oyster salesman from Seattle to the Beverly Hilton or Beverly Wilshire Hotel, which I think now owned by the Sultan of Brunei. I think that's right. To take, bone marrow samples, blood samples, and other samples. So the doctor said, we want to take good care of you because we really care about you. So Moore probably realized something was up, but I don't think he, from what I can gather, didn't really care because he was getting free trips to Los Angeles, staying in a posh hotel, whatever. He doesn't care. But at a certain point, he started suspecting that the doctors weren't being straight with him. And each time he went, he signed this form that said, I grant to the University of California the rights in my cell line and any potential product which might be developed from my tissue. So for years, he would always check, I do, right? I consent. Quote, you don't want to rock the boat. You think maybe this guy will cut you off. This guy will cut you off. Meaning he's getting all this free medical treatment. He's getting this free hotel. He's like, whatever. What do I care about the stupid checkbox? But at a certain point, he's like, okay, something's not right here, right? Why am I getting this awesome treatment? No one cares about me. And he checked, I don't consent. I do not consent. So then he left Los Angeles, and the doctor calls saying, hey, I think you accidentally circled the wrong option. And the guy says, I'm going to read his quote, gee, doctor, I don't know how I made that mistake. And he went back home to Seattle. And then the doctor mailed him the form to Seattle, and he said, circle I do. And he said, I don't. And the doctor sent him a letter saying, quote, stop being a pain and sign the form. So what did Moore do? What do you think he did? He hired a lawyer. He sent the letter to an attorney. Okay. So in hindsight, what was going on? Over the last 7 years, the doctor had used his cell line to develop he had used his tissue to develop a new cell line. I want to make sure you understand the difference. The tissue they're extracting from Mr. Moore is used to create new cells. And he got a patent on these new proteins, these new cells, which has a market valuation of $3 billion with a B. And this was a while ago, so I'm guessing the value has, the patent probably expired, but this was a lot of money. There are very few people whose tissue keeps generating cells even after death. We don't exactly know how it works. Did anyone ever know about this book? It's a really good book, The Immortal Life of Henrietta Lacks. Want to read it? Tell us about it. Did anyone actually read the book? Yeah, want to tell us about it?
She basically, I can't remember, it's been a long time since I read it, but she had some special cells and
Yeah.
the John Hopkins, I think, medical center was exploiting the cells for profit and wasn't giving it to her.
Yeah. So this was like on the bestseller list for like years. It's a really good book called The Immortal Life of Henrietta Lacks. And the premise here, she was a poor black woman in Baltimore who had some form of cancer. I think it was uterine cancer. And the Johns Hopkins Medical Center provided some free treatment for her. And, they randomly took a sample of her cells and they put it in a petri dish. And then, some guy was just watching it, right? Just out of curiosity, and it kept growing and growing. And I mean, it basically burst out of the petri dish, right? And what the hell's going on here, right? This is not supposed to happen. So they again invited Henrietta back to the hospital and they basically scraped samples from her. Okay, they never told her what was up. And then she died fairly young at the age of 30 or 31. She was really, really young, very sad. But her cells were used for decades to generate the cell lines. And in fact, the cell line was called HeLa, H-E-L-A. They reduced her name to an acronym, which is somewhat poetic. People even forgot her name. For a while, they thought it was Helen Lack. And then eventually, the author, Rebecca Skloot, found the Lacks family, and they were very, alienated. They actually brought her in, and it was an entire ordeal. But again, this happened nationwide, right? They would find these poor people who had no idea what their cells were worth. They would offer them free healthcare, scrape up their cells, and then make billions of dollars off their tissue. So this is going on in the background. I don't think when this case was litigated, the Henrietta Lacks story was quite public yet. But so the Moore case was like the first big case to discuss this. Okay, so this case is brought. He hires a lawyer. I think I'm up to, is that Julia? So Julia, what did the lower court do in this case? I'm sorry, louder, I can't hear. Okay, so well, by the way, I know you took torts last year, but let's try and see if we can remember. What is conversion? Yeah, basically using someone else's property. So if I take your notepad and I start writing in it, I've committed the tort of conversion, okay? Okay, so what does the lower court say about conversion? There was. Are you talking about the lower court? I'm asking about the Court of Appeals, not the Supreme Court. Yes, okay, you're right, yes. The Court of Appeals held that the University of California, the defendants, converted the property of, okay? The Court of Appeals said removing the cells and removing this, what do you call it, these tissues was an essential element of a person's property, that you had a property in your own person. Moore never abandoned his cells, the Court of Appeals held. Therefore, he's entitled to a share of the billions and billions of dollars that were generated by the cell line. This was the Court of Appeals. This was not the Supreme Court of California, but that's what the lower court held. Everyone got the lower court held? Okay. So, is that Veronica? So the case was appealed to the Supreme Court of California. And the Supreme Court of California had a divided opinion. So the first issue I want to ask you about is a breach of fiduciary duty. What does that mean, a breach of fiduciary duty? I'm sorry, a little louder. Yeah. So did the doctors in this case actually tell Mr. Moore what they would be using his tissue for? What did they tell him they were going to be using it for? Yeah, they basically said, look, we're just going to treat you and we'll dispose of whatever tissues you give us, no big deal. So the majority opinion, I don't want to dwell on this point for too long, but the majority opinion basically says, yeah, the doctors lied to him, right? They did not give him informed consent. They did not tell him what they'd be using his tissue for. And he could actually then sue for a breach that they did not tell him. Now, here's the rub, though. Is that Daniel? Why is that remedy not such a big deal? Why do you think Mr. Moore wasn't too happy with that part of the big deal? Why?
Because it's more about
What's the breach? I'm sorry. What's the remedy for a breach of this fiduciary duty? It's not much. Okay. The remedy, the damages for breach of the fiduciary duty is not much. Right? It isn't a lot. The damages for conversion is the value of the property itself. Everyone see that? Think of the breach of fiduciary duty like a breach for contract. What are your actual damages, right? How much worse are you because you weren't told about this, what they're going to be using it for? Whatever it is, thousands. I mean, it's a fairly quantifiable number. But the damages for the conversion remedy, that's where the money is. Because for conversion, you actually get the value of the misappropriated property, which again was in the millions or billions, whatever time it was. So even though the court ruled in the favor of Mr. Moore on the fiduciary duty claim, I don't think he was too happy about that. That didn't get him anywhere. So let's talk more about conversion. Let's see, is that Cesar?
Yes, sir.
So when we talk about conversion, we're talking about a person's property, what they have, right? Were the tissues in this case the property of Mr. Moore? Were those his property? Why did the court say no?
Because it had already been taken out of it.
Yeah. So the first aspect of the court's holding is that there's no property in the first place. as soon as this tissue, as these these body parts were removed from your body, you lost all property rights to it. It's as if it had been abandoned, right? The same way if you have a piece of property and you don't want it, you dump it in the woods somewhere, right? The court analogizes this to abandonment. The court says that Moore did not expect to retain possession after the cells were removed. If you'll recall, he actually signed that form that said all my body parts will be cremated or destroyed or buried, right? He did not expect that his tissues would be saved for him. So from that, they actually find abandonment. You're shaking your head no. Why are you shaking your head? What's wrong? Why does it seem wrong? And then what happens if you let the fox run away? Oh.
Yeah. Obviously he didn't, but if he filed an injunction saying stop using my cells, stop making it, I didn't properly consent to this, gotten an injunction, he ended up trying to go and force him to settle.
No, and that's the important part. The remedy for the lack of informed consent is to give more consent, right? He could not have gotten an injunction to stop it because the only remedy for the for breach of fiduciary trust is to actually give consent.
I personally disagree with the court's refusal to allow a person to have economic rights in their own bodily property. If these companies can make billions of dollars off of the person's tissues, I think a person should have the right to sell their tissue. I understand that there's the fear of more gray areas, but it seems like the court's making an arbitrary thing.
Put your hand up.
Yes, I was just gonna ask, would it have made a difference if he didn't sign the consent form? Like if he did have an interest to keep it, or would they still say it's not your property?
Well, let me ask this question. I was about to go to the next one. Is that who's next? Josh, under California state law, again, did the California legislature speak to this issue?
Yeah,
good, and this is the important part. And what did the legislature say about this in this section of the safety code?
The human tissues and anatomic human remains in effective place, following conclusion, are disposed of in consideration other than
Okay. So, very good. So, Josh, let me ask you this follow-up question. According to the legislature of California, what status does the government attach to cells removed from the body? Trash. Trash, right? The legislature of California, in their judgment, decided that cells removed from the body are trash. Josh, does that sound like something that you retain a property right body that the government can just deem it trash?
Once it's trash, I don't think you have the property.
Right. So what's interesting here is I think we have interesting moral cases being made by some of your colleagues, right? But once again, the California legislature made a judgment. Maybe it's right, maybe it's wrong. It can be changed. And this raises the question, which I think it's 3 consecutive cases, who gets to decide what status attaches to property? If the legislature makes a determination, can courts disregard that? What do you think, Madison? Yeah, that's why I asked it. Yeah, never. I remember when I was a 1L, I had moot court first time, and the judge asked a question like, "Your Honor, that's a good question." He said, "That's why I asked it." And I never asked the question ever. I never said ever again. So never say it's a good question. It's I asked it. So yeah, so Madison, I mean, the question is this, right?
I would say yes, the courts could decide.
Even if the legislature made a judgment to the contrary. Even if the legislature said this is trash, it's not worthy of any status.
So I guess the legislature holds them.
What do you think?
I think in the past cases that we've seen, they attempted to do their own thing and say, we're just gonna go with our common law
But
instead.
what they do here though? Did they do their own thing?
No, they went with legislature.
Ain't that something, right? So I mean, third time's the charm, right? The California Supreme Court, not known for its shrinking violetness, right? You know, they're usually all over the map. They said, look, we need to proceed delicately in this space. We need to proceed conservatively. This is a very controversial issue that raises a lot of emotion and passion and disagreement on all sides of the issue. People shaking their heads, yes, no, right? Let's not do this ourselves. If the legislature wants to assign a property right in a person's tissue, that ought to be the job for the legislature. And that's not something the courts should create by common law. Yes, sir. Is that Landon?
So then, would it be okay if I took my trash out, put it on the street, anyone can just go through it?
Even the police, yes. No, indeed, they're Fourth Amendment case on this. If you leave your trash on the curb, they don't need a warrant. They can toss it. So yes, generally abandoned property you have no claim to anymore. Professor Peters is nodding, so I think I'm on the right track.
Put it out on the curb and anyone can go through it. You got a meth lab in your house, everybody knows that.
Yeah, Breaking Bad. So where do we go? Yeah, Justin.
So, you put it out in the curb, is it trash because it's like a public domain?
You've abandoned your claim to it. I mean, the principles are actually in the same ballpark.
So like I know, for example, my parents live here too, like on their curb, their trash goes actually like on your property and they pick it up. So are you trespassing to go and look into that?
So you're moving astray, but the curb is actually a tricky area where the curtilage is, and I don't want to bore you with that. But generally speaking, trash is there. I remember reading one crazy case where there was actually a homeless person who claimed that his hovel of trash was his home, and there was some Connecticut court that actually said that he has a Fourth Amendment right to his little hovel of trash. But I think that's the outlier. Any other questions? Yeah, that's hold on. Is that Sarah? Yeah.
I think there's, I can't remember where I read it, but that said that you couldn't sell like transplants.
Oh, good. I'm gonna get to that in like 2 minutes.
Oh, okay.
I promise. I'm gonna get there in 2 minutes. I promise. So I'm gonna get right there real quick. Yes, you can sell transplants. So the court effectively says here, right? What the court effectively says here is we're not going to be the ones to make this new policy, right? We don't want to have to chill an entire area of industry. The same argument about effectiveness, right, and incentives. Because, is that Fanny?
Yeah.
Fanny, let me ask you this question. If the court were to hold it the other way, and the court held that, you know, any person whose cells are being used gets a 50% cut of, you know, this entire cell line, what do you think that would do to innovation and the incentives to create?
I think it would limit it.
Why?
I mean, industry, they wouldn't want to invest as much money in product knowing that.
Yeah. So imagine you want to start a new business, right? A biotech company. And you know that at any given point, some guy comes along and says, hey, give me half. Those are my cells. No investor in the world would ever fund a company like that, right? If you understand anything about startup companies, you give them, you know, 5 or 10% to an investor, but giving half of your profits to someone else, it would decrease the incentives. Yes, that's, is that Cody?
But I think if you look at it that way, you're missing the fact that you're giving power to the individual to become a creator themselves, right? Like they can go and intentionally pay for their genes to be sequenced, knowing that they have a potential to profit off of it, or that they don't. So you're not destroying the need, the want to create.
Yeah. So Cody raises a fair point, right? I think the question becomes this: who here knows that their cell's worth $1 billion? Does anyone? No. You only know your cell is worth $1 billion when some smart scientist, much smarter than me, right? We're lawyers. I don't like blood, so I went to law school, right? When one of these people decide to sequence it and to do something with it, to actually create with it. So there's a collaborative process, but I think there is a fair point.
How is it different from the intellectual property rights of the writers and the thought that created?
Who creates the laws concerning copyright? Which branch of government? Thank you, ma'am.
I mean,
Could the legislature here create a right to sell property? Could they? Yes. And that's the other thing that law students don't get. even after this decision, the legislature can come back and pass a law saying we want to give a property right in your cells.
But it mentions the public policy here, like it's imposing a tort duty on scientists.
Yeah.
To like actually go back and look at each individual cell, like whom it belongs to. And I guess that's, you know.
Could that be accomplished by statute?
I mean, it could, but I mean, it also raises the question of efficiency. But wouldn't that also, shouldn't that same public policy be raised in white, where
In where? Oh, Vanaway,
in
yeah.
white, where like the writers and the they took their time to create this image, so their intellectual property is protected.
So the short answer to both of these things is that the legislature can make good decisions and the legislature can make bad decisions. When you say public policy, that's what the legislative branch does. They make public policy. The thrust of the majority opinion is let the legislature decide, not us. Let's move on to the concurring opinion. Very short by Judge. Is that Karima? What does Justice Arabian say? It's a fairly short concurring opinion. What's his point? Do you have it?
Is this the one that he talks about how like humans value the body and how like slavery was?
Yeah. Yeah.
So basically he's just saying how humans value the body and you can see that through like slavery became legal and then all he talks about equity and the ethics of it.
Good.
And how humans should have control over their own body.
Good. Okay. So Justice Arabian has a position that's somewhat unique. He says, look, there is something wrong about selling body tissue. There's something immoral about selling body tissue. He says the body is the single most venerated and protected subject in civilized society. You are now commingling the sacred with profane. He says the effects on human dignity of a marketplace of human body parts is not for us to decide. This is for the legislature to decide. Okay? In effect, he takes this view, and this is we talked about John Locke in weeks past, but the view is we all are born with a natural right to possession of our own body, and that no one can own our body. In fact, this is an argument that traces its roots to slavery, that one of the primary abolitionist arguments was that no one can own another person, that it violates these fundamental tenets of the laws of nature. And for Justice Arabian, at least, the idea of people selling body parts and trafficking body parts brings him back to slavery and makes him think of a slave. You sell your organ, you sell your leg or kidney, whatever it is, you're selling a person. And for him, this is. I mean, he says leave it to the legislature, but you can guess he thinks this is really, really wrong. Is there a hand up?
Yeah.
Okay. So to the point Sarah mentioned a couple minutes ago, under our laws, let me ask like this. So who here has ever donated plasma? Not blood, plasma, right? Because plasma gets you the money, right? Everyone knows this, right? You don't get any money for donating blood. How were you able to get paid for donating plasma? Do you know?
Yeah, you just go in there and sell your plasma. It's like a donation.
So let me ask this a little bit more if I can. Who has ever gotten paid to donate another aspect of male anatomy? Let me put it that way. I'm saying this for a reason, I promise. No one's raised their hand. That's fine. Why is it that you're able to donate plasma but not able to donate a kidney? Do you know the reason? Yeah. You can regenerate it, right? If you drain a person's, how often can you donate plasma? What's the limit? College students usually know this sort of thing, right? There's always a plasma bank in a college town. I promise you, there's one. Yeah, I mean, look, it's rent money, right? Yeah, I can't get blood. I faint. But the point is, blood, semen, plasma, they regenerate. So the law has effectively said that if something regenerates, you're allowed to donate it for profit.
You can sell your liver. I'm just curious.
Organs don't regenerate.
Your liver absolutely does.
Not the entire organ.
Yeah.
If you slice a slice. Organs are considered different. Something called the National Organ Transplant Act, which says basically if you can't regenerate, you can't sell. Now, one interesting issue is bone marrow. Bone marrow does regenerate. And for whatever reason, I think it was a mistake, the National Organ Transplant Act said you can't sell bone marrow. And this was actually a very, very bad decision because people need bone marrow. And when you have money available, like my fine friend over here, there are incentives to actually donate. And bone marrow is a fairly rigorous procedure to extract it. This is not like, you know, getting a needle to your arm. Litigation about whether a bone marrow can be transplanted. But the short answer is you cannot donate it. Yes, sir. Oh, wow, 2 for 2. Yes, that's, hold on, Elizabeth. I think with eggs, there's a fairly large enough supply that it's considered almost regenerative. Yes. The law here is not entirely consistent either. But yes, you can be paid for donation of eggs as well.
Did it also say that you could sell your remains for
Yes.
further science?
So this is the other point. So the dissent, and I'll just lead into the dissent. The dissent by Justice Mosk effectively says, we already have a system where you can sell body parts. After you die, you can donate your remains to science, right? You've probably heard this, right? You can donate your cadaver to science. You can donate your organs, and you can be paid for it. So the dissent says it's simply not true that our public policy considers organs trash. Perhaps they've only considered donation after death because until fairly recently, you couldn't really take out an organ of a person and they'll still be living, right? I mean, the idea of living with one kidney, you know, is a fairly novel invention, right? I mean, now you can do it, I suppose, or one liver, but that's actually fairly novel. Dissent also makes a number of interesting points, right? Where they say, just because you have some piece of property doesn't mean you can do whatever you want with it. There might be a limited use of it. So one example they give is a law license, right? If any of you, God willing, all of you pass the bar in a couple of years, right? Study, study, study. You all pass the bar in a couple of years. You get this nice piece of paper on the wall that says, you know, so-and-so is a member of the Texas bar. What was I up to? Okay, so Samuel, if you go on Craigslist, right, and you put your law degree on Craigslist, or you put your bar license on Craigslist, and some guy buys it for $20, right? Depressing, I know. Does that person become a lawyer?
No, but I might get sanctioned.
Yeah, you might. The point is, merely owning something does not give you full rights over it. So I'll give you another example. Adam, have you ever been hunting? So there's certain types of game, right, where can you gift anything you hunt to someone else? Can you sell it? No. So it's interesting, right? Sometimes you can have property, you can give it away for free, but you can't sell it. Right? Yeah. I'm sorry? I think there's special rules about hunting in game. So the short answer, right, and this is what the majority of dissent kind of argue over, is can you have a property right in something that's not absolute? Right? This is a concept I want you to think about throughout the entire semester. Just because you have something doesn't mean you can do whatever you want to it. In the same sense that you all get a bar license, which entitles you to be a lawyer, you can't sell that. Or if you go hunting and you catch a, some sort of animal, you can gift it, but you can't sell it. So the notion that you may have some sort of property right that you can do some stuff to, and on others, should be comfortable to you, right? You may not think about it. Okay. All right. So questions on the majority of the dissent and more, right? We have this rule where the majority basically says it's not for us to decide these sorts of controversial issues. Let the legislature decide. And oh, by the way, policy reasons suggest we shouldn't do this because we want to create incentives for creation. And the dissent basically says, no, this is rubbish. The law already allows you to dispose of body parts in certain ways for profit. This is a simple extension of the conversion doctrine, right? We still have these conversion doctrines. There's no big deal here. We can donate, plasma for money. Those regenerate. We can donate eggs for money or semen for money. These cells regenerate just the same. There's no problem here. Everyone get that? So Thomas, what do you think the consequence of this decision was? What do you think the effect of this decision was on hospitals and researchers?
Made future patients more aware of what they actually do.
How will the hospitals and doctors make their patients more aware? You're exactly right.
Probably include it in some form of informed consent.
Right. So basically the upshot of this case, right? The upshot of this case is that informed consent laws became much more rigorous, where instead of just signing some generic form, these things became much more detailed. Okay. Any questions? Yeah, Sarah?
We're getting lots of competing things. And
Welcome to property.
And I guess I need to read the tests that you did before, I suppose, but I'm worried that I don't know where to go.
So I said this in the very first day of class, that there's no UCC for property. There's no restatement. There's a restatement, but it's worthless. You notice I haven't even mentioned it. There is a restatement of property. There's 3 of them. I haven't mentioned it because they're worthless. No one follows them. Property law is very, very fragmented. And one of the difficulties of this class is to keep track of the different schools. And my sincere hope is that you see certain patterns that actually prevail through all these, whether focused on efficiency or fairness. Those are the themes to think about. But again, there's not one single rule. Not going to help you. Yeah.
So I guess follow-up question: does that mean that if we argue a case well enough, that in spite of prior rulings, it could go either way?
There's no one right answer to my exam. I want you to look. They're all online. Every exam I've ever given is online. Look at it. There's not one right answer. They're all open-ended. So I want to mention one fact. In terms of the organ sale thing, there's a fairly robust argument that organ sales should be allowed. Because every year, tens of thousands of people die waiting for organs. And generally, most donations are from next of kin and related. And if they're not a match, it doesn't work. And I use this example. So Steve Jobs, the Mr. Apple, Mr. iPhone, right? He was able to get, I think it was a liver transplant. Do you know how he was able to get a liver transplant? He registered in all 50 states to be on the wait list. He basically established domiciles in all 50 states. And Tennessee was the first one to get him. Even then, it was fairly shady because he basically established a domicile in Tennessee. Who was living there? His doctor. And then, there's this beautiful mansion in Tennessee, and he's able to get a liver transplant. Flying a helicopter from California to Tennessee. So it effectively is already the fact that people who have money can buy organs as transparent and not have this sort of shady black market. Any other questions? I will see you on Thursday. Thank you much. And please bring the attendance sheet back up.